Hello, everyone, and welcome to the Career Advice Series webinar, How to Become a Freelance Lawyer, Rates, Contracts, Legal Ethics, and more. I am Emily Roshek, Associate Director of ABA Legal Career Central, a career center that offers both career development resources and a job board for law students, lawyers, and other legal professionals across all disciplines and career stages. It is my pleasure to introduce our speaker today, Erin Giglia. Erin is co-owner and founder of Montage Legal Group. Erin graduated from Wellesley College and from the University of San Diego School of Law. She practiced law for 8 years at two law firms, Brobeck and at Snell and Wilmer LLP, before she founded Montage Legal Group in 2009 with her business partner, Lori Rowan. Montage is an exclusive freelance attorney network that assists law firms with legal projects on an hourly or project basis. Montage has been featured in numerous articles and publications, including Forbes, ABA Journal, The Huffington Post, Above the Law, and The Atlantic, among others. Montage Legal Group's unique business model has been discussed in various books, including Life After Law, Overwhelmed, and Lawyer Interrupted. For more information, see montagelegal.com. Thank you, Erin, so much for being here. I will now turn it over to you.
Hi, everyone. Thank you so much for attending this presentation. As Emily said, I'm Erin Giglia, co-founder and owner of Montage Legal Group, which is a freelance attorney network. Unfortunately, my brilliant business partner, Lori, is unable to be with us today, but hopefully I'll be able to adequately cover this two-woman job. So Lori and I have been in the freelance attorney world since 2009. Since then, I've talked with thousands of people struggling with career choices and have picked up some tools of the trade that I'm going to share with you today. Let's move along some slides. Okay, so as you can see, I'm going to be discussing what is freelance legal work, who can freelance and why, how do freelance lawyers find work, what do you need to get started, setting your rates, legal ethics of counsel titles, best practices, and pitfalls to avoid. I'll also do my best to answer your questions as they come through. I won't be able to get to all of them, and it might be tricky to shift between slides and questions, but I'll do my best, and please bear with me. So first, what is freelance legal work? There are a lot of ways to describe an outside lawyer who temporarily assists a law firm, but we usually refer to this person as a contract attorney or a freelance attorney. I'm going to use these terms interchangeably, and for the most part, they mean the same thing. Both terms refer to a temporary lawyer who works for a law firm or another lawyer on an hourly or project basis instead of representing clients directly. So if there's an attorney who is representing people or businesses, that's just a solo practitioner. It's not a freelance attorney. A freelance attorney must be working for another lawyer. There always must be another lawyer in between the actual client or the freelance attorney. A freelance attorney is usually working remotely, although not 100%, and it's going to be on an hourly or project basis versus receiving a salary. Who can freelance and why? So who can be a freelance attorney? Basically, anyone who is admitted to practice law in the US, but there are special considerations for different kinds of lawyers. The most successful freelance attorneys are typically attorneys who have been practicing already between 5 and 20 years. These lawyers are already trained and they already know what to do. The reason for this is it takes about 5 years to gain confidence as a lawyer. That's pretty normal. It doesn't mean that's universally true, but it's just fairly common. Firms that need help need to be able to hand over a project with very basic instructions and then turn to whatever other tasks they're dealing with. That's why they call a freelance attorney. So for example, a law firm might say, I need you to oppose this motion for summary judgment. Here's the file, and here's the discovery, and here's the moving papers, go oppose this. If you're a brand new lawyer, it might be very difficult to complete a task like that without direction. I'll get more into this in a minute. So I'm going to start talking about these different categories that I have here. I'm going to start from the bottom up. So lawyers who might be close to retirement and want to wind down their practices can freelance for other law firms. These lawyers can be tremendous resources to law firms for the obvious reason that they're extremely trained. They have an entire career behind them. The challenges for these types of lawyers is that some firms are reluctant to hire a very senior lawyer because they're afraid that their rates might be too high. Or they might be afraid that the senior lawyer might not want to take direction. So with all of the challenges that I'm going to address, I'm going to explain what they are, and then I'm going to wait until the end and to explain how to overcome these challenges later. Okay, so the next group is an entrepreneur. This type of lawyer might have some other type of business or interest that's keeping them busy, and they want to also do some legal projects to keep their hand in the law. So this is fairly common. A lot of lawyers have other interests. They don't want to work full-time as a lawyer, but they want to pick up work here and there. They might be an author or an actor or some other thing. The challenge for these types of lawyers is that some firms might be afraid that they're not going to be paying as much attention to the legal projects as the firm would like. Their attention might be scattered and directed to their other endeavor. Okay, so the next type of lawyer is the solo practitioner. This is a solo lawyer that's looking to build their business, and they're looking for a second income stream. These lawyers can do great can do great freelance work. The challenge that needs to be overcome is that some firms are concerned that these types of lawyers might try to go after their clients. A lot of the time it's completely unfounded, and I would say 99% of the time it's unfounded, but it's still an issue that needs to be overcome. And then we have lawyers seeking work-life balance. This model works especially well for these types of attorneys because these lawyers tend to want fewer hours. So law firms might be looking for help here and there, 5 hours a week, 10 hours a week, 15 hours a week, which works great if that's what you're looking to do. This type of scenario can be a challenge because if you are providing a good service and you become popular with different law firms who enjoy working with you and giving you work, the challenge becomes not overcommitting. So what do you do if you get too busy? Do you turn away work? You don't want to be working 40 hours a week, which is why you're doing this to begin with. So that's the challenge here. Now, the last category is the new lawyer. And this is the trickiest. So I'm going to spend a little bit more time talking about this one. So let me go back. Before I do, I'm going to go back and talk about how to overcome the challenges that I just mentioned. The way to overcome all of these preconceived notions that firms may have about these types of categories of lawyer is to address them at the beginning. So when you meet someone, if you're a lawyer that's looking to go into retirement, wind down your practice, for example, you might say something like, I know I'm a really senior lawyer, but I'm not interested in hustling to get my own clients anymore. I just like to be really useful to another firm and take a back seat and do legal projects whenever you need. Or for the solo practitioner, you might say something like, I understand that these are your clients and the relationship is with you. I'm happy to be completely behind the scenes, or something like that. So just communicate in a way that makes it clear that whatever fear this law firm may have in giving you work is not going to be an issue. All right, so now I'm going to talk about the new lawyers. So most firms are not going to call a brand new lawyer if they need help with high-level substantive work. The reason is, like I mentioned before, they're really busy and they don't have time to train someone. They're not looking to go through and revise, go through 4 drafts of a document before they have it filed or what have you. They need to have the ability to give the project and get it back in a way that's going to be complete and final or really close to it. So how do we fix this? How do we get the work that we need? How do we get the training if that's the reality? Well, the best way is to find someone who's willing to train you. It's not easy. I will definitely admit that. And the only real way to do this is to go out and meet these people. They do exist, so it's not impossible. The way to do this is to meet as many people as possible, and you need to be able to tell them in the most professional and lighthearted way possible that you're available to help. You can't have an ego about it. You have to be willing to do basically any project that is, ethical. So if someone asks you to do something that's wrong or illegal or doesn't exist, then please say no to that. But aside from that, they're going to ask you to do really basic work. And if you're a new lawyer looking to be trained, then you need to be okay with that. So how do you do this? Well, you need to go and meet people in person. You need to show up to attorney networking events. If you have a local bar association, you need to show up to those types of events. You need to network online with people, meet as many people as you can. And the way to handle it is to ask for introductions. Do not ask for a job. So if you go to a local bar association event, you have to go in, you have to talk to strangers, you have to tell them who you are, and you have to ask for introductions. That's really the best way. So what if you want to be a certain kind of lawyer? How do you make that happen? Well, again, meet as many people in that field as possible, offer to ghostwrite articles for them, take all the CLE classes that you can in that area, and start writing articles of your own, get them published, turn them into your own CLE presentations. This requires a lot of work and a lot of networking. The ideal situation, if you're a young lawyer wanting to do this, is to find 1 or 2 firms that are willing to take you on as consistently as possible as a part-time associate and train you. Find a busy solo practitioner. Who can freelance? The bottom line is the best type of person for this is someone who actively wants to be a freelance attorney, who wants to be practicing in this way. If you want to do something else, then this is a difficult thing to do in the meantime because it's a relationship building scenario. Okay, I've touched on this a little bit, but how do freelance attorneys find work? Same type of answers: network in person, network online, email your contacts from college or law school, your former colleagues, or you can apply with a staffing company or a freelance attorney network. These are all fairly obvious answers, I think, but networking in person is, it's like I said, it's the trickiest. You always want to try to go in and ask questions instead of trying to ask for something. The more helpful you can be to someone else, the more likely that they will want to be helpful to you. Okay. What do you need to get started? So it's always a good idea to have a written agreement with a law firm that's bringing you in to help. This way you have all of the information on paper, you have your rate, you have the parameters of how you're going to help this firm, you have, how you're going to deal with payment, other things of that nature. You'll want to get a professional email address. If your email is, kittenlover@gmail.com, maybe you should change that to something that's going to be a little bit more professional, perhaps just something like Samantha@samanthalaw.com or something of that nature. You definitely need a computer, a scanner, an internet connection, and a phone. this is fairly obvious. Like 97% of the work that freelance attorneys end up doing is remote, and so you'll definitely need all of these things. Optional. Business cards are probably a good idea. This way you can hand them out to people when you are going to your networking events. A website is a good way to let people find you, but even more important than that, it's a good way to have a method that people can go to when they want to do some research about you. So if you go to your network event and you meet someone, the first thing they're going to do before they give you any work is they're going to look you up. And if they have something like a website that they can go to, then it's your content that they're going to find, and it'll be in a way that you want to present yourself. Okay, a Lexis or a Westlaw password, these things are not necessary most of the time because law firms will provide them. There's also a lot of really excellent free resources that are becoming increasingly better and better. So, of course, if a law firm wants Lexis quality research or Westlaw, then they're going to have to provide it or adjust their expectations accordingly. The other thing is malpractice insurance. Now, this is a tricky area that is absolutely full of gray. So I'm going to touch on this a little bit. And the answer to this question is that there's really no clear answer, but I'll talk about it as best as I can. So when you're doing contract work for another lawyer, 95% of the time, you're absolutely behind the scenes. Your name is not on anything. You're not signing anything. You're ghostwriting in the background. So, because the law firm is the entity that is adopting the work that you've provided, it's the law firm's insurance that should be implicated in the event that there's any issue. Now, this is not a risk-free endeavor. I mean, there's no such thing as a risk-free endeavor. The risk is low because can a law firm come back or can a client come back and loop you into a malpractice case? Sure. People can sue anyone for anything at any time if there's not going to be any protection. But the law firm's policy should be the one that covers. Now, there's a couple wrinkles in this, complications. So one of them is, according to the ethics opinions, which I'll get into in a minute, the work that you're doing, if you're ghostwriting behind the scenes, is not even considered practicing law. And because of that, it's arguable that even if you have your own insurance policy, how would that cover what you're doing based on the ethics opinions? The other thing that's tricky is if you have your own policy, you don't have an independent engagement with the ultimate client that would trigger coverage. So what I always recommend is that you contact your carrier or contact a carrier if you're interested in coverage and tell them, I'm going to be doing contract work for other law firms. What do I need to do? Is there coverage for me? And likewise, if you're going to be working for a law firm, it's really important to say, do you have malpractice insurance that covers me? First of all, the number one question should be, do you have malpractice insurance? Because in some states, my state, California included, malpractice insurance is not required. The law firm has to disclose to the client that they don't have coverage. But if there's no malpractice insurance, that might be something you would be interested to know, because that means you're not covered by the firm's malpractice insurance if it doesn't exist. So it's important to ask the question in that since 2009, since we've been doing this, we have had zero issues, knock on desk. But it still is something that lawyers who are cautious people, in general, tend to want to know. So just ask, do you have malpractice insurance? Does it cover contract attorneys? And then let that be your guide to decide if you're interested in handling the work or not. If it's a basic research project, I mean, maybe it's probably fine. If it's second chairing a trial, then you're going to be more exposed. If you're leading a deal, then yeah, you're going to be more exposed. So you just need to use your own discretion. Everyone has their own level of risk aversion to decide what is going to make the most sense for you. Okay. Setting your rates. This depends on a lot of things, and this is going to be painfully vague, and so I'm going to apologize in advance. Setting your rates depends on your experience level, the project, the area of law, and really your own personal decision. How much do you want to make? How much can you get? Obviously, the higher the rate you receive, the better off you will be. I always recommend to people, and before I even get into my recommendation, I want to mention this. I fully recognize that everyone comes into this scenario with very different economic circumstances. Some people have a secondary income source, and they're doing this because law is something that they enjoy doing. They want to keep their foot in the door. They want to make some vacation money. Other people who want to do this need money for food and shelter. These are obviously very different considerations. So the person who doesn't actually need money is going to probably ask for a higher rate than the person who really does, who wants to get more work. So I recognize that, and I cannot tell anyone what rates they should and should not take because everyone's life is completely different. So of course, like I said, you want to get the highest rate possible without scaring the firm away. You want to make it attractive to the firm to utilize your services, but at the same time, you really don't want to undervalue your skills. So again, this depends on experience, the project itself, the area of law. If you're a very experienced attorney, then you're going to be able to charge more than a brand new lawyer. If it's a very basic project, then probably a firm is going to want to pay less than if it's extremely substantive and complicated. If it's a very complex area of law, for example, healthcare transactional or tax or some other thing like that, then those rates are likely going to be higher. If it's something that's fairly common, business litigation, for example, then it might be, the rates might be lower because the number of people who are able to help with that might be more. So the more flexible you are with your rate, the more likely you will get projects. There's going to be more work. The more you say yes, the lower your rate is, the more flexibility you have. The other thing that as I mentioned before, my recommendation is always this. Don't say yes to a rate that's going to make you sad or annoyed. And I say this because if you do, then nobody wins. It's human nature to do a better job when you're feeling happy and valued with the work that you're doing. And if you're saying yes to a low rate that makes you sad or irritated, then the firm is probably not going to be thrilled at the end of the day. Sometimes it's okay. Maybe you're, not really busy that day or week or month, and you're fine with taking a lower rate, or maybe the project is interesting to you or satisfying in some way, and so you want to take a lower rate. That's all fine. But just, like I said, economic considerations are going to be different for everyone, but in a perfect world, just find a rate that's going to make you feel happy and then ask for that. If you can talk to friends or, talk to people in your market, that might also, that might affect the rate that you would be charging. Even talk to firms. If a firm wants to hire you and says, what do you charge? You can say something, or you can ask, well, what do you normally pay? And see if you're okay with that. And if you are, then great. And if you're not, then feel free to decline it if you're able. Okay, so rate range. For document review, and I will say that I really have very little experience with document review companies, and so this is based on just in general what I've heard, that document review attorneys tend to get between $25 and $30 an hour if you're working for one of these big companies, these e-discovery companies or what have you. Newer lawyers, probably because you don't have experience at all, I would guess would be probably between $30 and $50 an hour. And for the experienced lawyers, there's really a wide range. I mean, 75 an hour maybe, all the way up to, you know, 250 and above, 300, even 350 or 400 if you're very, very specialized and firms need you. For example, I'm aware that there are some very specialized lawyers that work with big firms that need their expertise, and they can charge, you know, $600 and up an hour. But again, that's far more rare than the norm. So these are just examples of rates, and it just depends on so many different factors, including, you know, just your individual self. Okay. All right, I'm going to touch on some legal ethics. I'm not going to get into this because this is an entirely separate CLE that I do. The first is conflicts of interest. You need to check your conflicts. If you're aware of the parties, you need to keep a list, keep it in Excel or Word or whatever is going to make sense to you, so you can clear conflicts with the firm, with the matter that you're handling. In a perfect world, you're going to avoid imputed conflicts of interest, and the way to do that is to have the firm limit your access to client information to the information that you need to handle the exact project or projects that you're doing. So if a firm wants to give you access to all their client files, that's probably not what you want to have happen, because although it's not the end of the world, if you're going to take work outside the firm, now you have to clear conflicts with the firm and vice versa first, which can just be an extra step that really is avoidable if possible. The other thing with the conflicts of interest is, on a more practical note, if you're a freelance attorney in a small legal market and you're limiting your work to that market, it could be really awkward to do freelance work for one firm and then do freelance work for another firm if those two firms are opposing each other in multiple matters, or even one matter. I mean, you obviously can't work on both sides of the same case. So how do you handle that? Well, again, this is really up to you. If it were me, I would probably pick the firm that's going to give you the most work and go with that firm. Because there's no imputed conflicts most of the time with freelance attorney work, then you don't have to worry about your conflicts traveling with you. It's just your actual conflicts. So for the most part, lawyers in a community don't know, they don't know who you're doing freelance work with. They don't know who's giving you projects. So it's probably not going to come up much. But again, this depends on how big your community is. If you're working in a community of 500 people, then it's going to be very different than if you're freelancing in New York City, where there's thousands of lawyers. So it's just something that you're going to have to do at your discretion. Okay, aiding and abetting. Again, the ethics opinions have all been clear that the work you're doing behind the scenes is not considered practicing law if you're ghostwriting. If you're working with a firm, they're not aiding and abetting the unauthorized practice of law by bringing you in if you're not admitted in that state. So for example, I'm in California, I can do freelance work for a firm in any other state if I'm doing it behind the scenes, and that's not considered practicing law. I tend to explain it kind of like it's like a local counsel arrangement, for example. So when I was practicing, I was National Discovery Counsel for a big company, and I used to do all of the discovery responses and motions in all the different jurisdictions across the country where we had cases. So I'm writing motions in, Alabama and Colorado and Kansas and all these things, but that's not considered practicing law because the law firm that was local in those locations was taking my work and making sure it complied with all the local requirements and signing it under their own pleading paper. And so what I was doing was completely ethical. There's no aiding and abetting issue. The same thing. So if I'm in California, I can do freelance work for lawyers in any other state, and that's completely fine according to the ethics rules. The duty of competence, essentially the firm that's hiring is the one that is on the hook. The duty of competence cannot be discharged by bringing someone else in. So it's going to be completely on the firm that's hiring. I've got a question here about a link or a source for out-of-state freelance work ethics rules. It's, can you provide a link or a source for this out-of-state freelance work ethics rules? The links are on the bottom here of the slide, the ethics of contract lawyering and stay ethical while growing your firm. We discuss these rules in depth in those two articles. Okay, so for the duty of competence, the firm cannot discharge it by bringing you in. So if a firm brings you in, let's say you're a tax lawyer and the firm specializes in personal injury work and wants to bring you in as a tax lawyer and they're behind the scenes. Well, it's not impossible for the firm to get up to speed in tax, but it might be difficult to say that that firm is completely competent in that very specialized area of law. If it's something that's, let's just say litigation, for example, if I'm an employment litigator and someone asks me to do real estate litigation, then it's a little bit more possible that, that the firm is going to be able to get up to speed on my specialty, and vice versa. The duty to disclose to a client is the one that people get a little bit hung up on. What do they have to tell their clients? People do a lot of different things. Some people, with the work you're doing, is completely behind the scenes. Other times they want you to have client contact. The duty to disclose to the client depends on the ethics rules, and that is if it's a substantial development in the representation. So if you're doing a basic research memo or doing some ghostwriting behind the scenes, it might not be a substantial development. If you're doing something major like leading a case or a deal or making appearances, then it's probably going to be a substantial development, and the firm will need to disclose it. So the other thing is that there's a few ethics rules that indicate that if the firm is going to mark up your rate to their client, then that may be considered a substantial development. And at that point, they need to disclose to the client that you are an outside consulting lawyer and your rate is whatever they're charging you, whatever they're charging to the client. There's nothing in any ethics rule that I've ever read that indicates that they have to tell the client what they're paying you, just like they don't need to disclose to their clients what they're paying their associates. Allowable fees, I just touched on this. Firms are ethically allowed to add a surcharge to your rate as long as the overall rate is reasonable. That's to be expected. Some firms want to double, triple, or even quadruple the rate that they're paying you. That's one of the benefits of using a freelance attorney. Some people don't like that, but oh, well, this firm is charging $600 an hour for my time, but they're only paying me $100 an hour. That's not fair. Okay, well, that's a consideration that you need to make if you decide to continue working with that firm. If you want to go back and try to renegotiate your rate, then you can feel free to do so. I would say as long as you're okay with no longer working for that firm in case they decide that they don't want to work with you anymore if you're asking for more. These are things that this is just a reality of doing this type of work. Fee splitting, as long as you're not getting paid on a contingency, then there are no fee splitting issues. So what I mean by that is if the firm has to pay you regardless of whether or not they're paid by their client, then there's no fee splitting issue. So if a firm says to you, well, for example, in your agreement that I mentioned at the beginning, I want to pay you, but I only want to pay you if my client pays me. Well, now that's a client fee. And now there may be fee splitting issues that need to be disclosed to the client according to certain ethics rules. If in your agreement it says, the agreement here is that I'm doing your work regardless of whether it's billable to your client, regardless of whether your client pays you, then that's no longer a client fee according to the ethics rules, and there's no fee splitting issue. I already talked about the malpractice insurance. This is a very individual consideration. Again, many shades of gray. So this is going to be completely up to you and your own risk aversion. I always recommend that people just go ahead and talk to a carrier, find out. Usually part-time policies are fairly inexpensive. They tend to not be cost prohibitive based on the money that you could make. Some people decide that they want to get some work flow happening and then get malpractice insurance at that point. That's fine too. Again, it's really up to you and your own decisions. Okay. All right, so the of counsel title. This is something that firms want to do a lot. Firms want to bring in contract attorneys and call them of counsel and put them up on their website. Why do they want to do this? Well, they do it because it makes them look bigger and better and capable of taking on more work. This is all fine as long as it makes sense based on the definition of counsel. So if someone asks you to do this and they're giving you 5 hours of work per year, then probably that doesn't meet the definition, because as you can see from the slide, the definition is a close, personal, continuous, and regular relationship. So again, it's a gray line. Is it 1,000 hours a year? Is it 500 hours a year? Is it 100 hours a year? It's kind of tough to say. So the tricky part for the contract lawyer to be called of counsel is ethical and also practical. From an ethical standpoint, if you are considered of counsel, then you carry automatic de facto imputed conflicts of interest with that firm. That's it, you're done. You have to clear conflicts with the firm if you want to work with more than one firm. Again, not an impossible obstacle to overcome, but it's something that can be awkward. And if you can avoid it, it's probably better to do that. Substantively, if it makes sense to be of counsel, so for example, if you have access to their client files, if you're going into the office for meetings, if you're working for the firm a lot, those types of things, then you probably have imputed conflicts anyway. And so an of counsel title is going to make very little difference. You're going to need to clear conflicts regardless. However, the other side of it is practical. So what happens when a firm wants to give you contract work for the first time? Before they do it, they're going to Google you. They're going to look you up. And if they find that you're of counsel at 3 different law firms, now they're concerned, because what does that tell them? Oh, this person has imputed conflicts with 3 different firms. They're going to have to clear conflicts first, and this person is probably busy, and they may just be confused in general. So it's not ethically impermissible to be of counsel at multiple firms, but from a practical standpoint, it can be really confusing to firm number 2, 3, 4, 5, 6 that wants to give you work. So if you are doing freelance work, you're going to potentially need work from several different sources, and it can be tricky to do that if you're getting multiple, if you're of counsel at multiple firms. Okay. So best practice here is don't be called of counsel if you can avoid it. let them call you something else: attorney, counsel, consulting counsel, whatever they want to call you, but not of counsel. And then the website issue. Think really hard before you let a firm put you on their website. If you are a new lawyer looking to build up your resume, then maybe it's good for you to be on the website, as long as you've fully considered all of the other issues. If you are already an established lawyer, then firms are going to be very attracted to the idea of putting this person with an amazing background on their website, because it makes them look better. You make them look good. So that's great for them, but just make sure it's also equally great for you before you say yes. Okay. Best practices. The number one complaint I ever hear about a contract attorney is that they're not responsive. So I know how tough this can be. We get bombarded with emails and phone calls all the time from 1,000 different directions. It's really hard. A lot of people are doing this type of work because they don't want to be sitting in front of a computer for their entire life. I completely understand. But firms do need to hear from you, because I don't know if you know this, but lawyers can be a little hyper sometimes. So really, it's natural. They just want to know that their work is getting done. And if you say you're going to get back to them at a certain time, then do it. Even if it's to say, hey, thanks, I got the project, I'll get back to you tomorrow. They just want to know what's happening. So you need to be responsive. You need to turn projects around as quickly as you can. The worst thing that can happen for a lot of people is a firm might say, oh, there's really no deadline on this, just whenever you get around to it. That's probably not true. There probably is kind of a mental deadline. And if you sit on a project for 4 months, they're not going to give you another project until you give them the first one. The quicker you turn a project around, the quicker they're going to give you another project, which in a lot of cases is the goal. So the next one is to set time expectations up front. When a firm gives you a project, it's really, really critical that you're on the same page with the firm about how long they want you to spend on the project. We all have been in situations where a project starts out and it seems simple, but then it becomes really complicated and you start going down rabbit holes that you didn't even know existed. You can't do that in this type of scenario when you're working with someone who has the client management side and they know what they can charge their client, but you might not. Even if the work is completely justified, you need to be on the same page as the hiring firm. So, for example, if a firm says to you, take all the time you need on this, that is never true, ever. You have to force them to give you some type of parameters, or at a minimum, you have to give your own parameters and say, this is going to take between 5 and 10 hours. Let me know if that's fine. Because if they come back to you and say, oh no, I want you to spend 30 minutes, now you know that you can either decline the project because there's no possible way this is getting done in 30 minutes, or you can have a conversation with the firm at the beginning and say, oh, well, actually, this is a really complicated issue, and here's why, and this is why I think it's going to take longer. Let me know if you want me to do it. The worst thing that you can do is spend your time doing a project completely justifiably and then have the firm turn around and say, oh, no, I didn't want you to do that. I'm not going to pay you. Don't do that to yourself. So the example that I've been giving for about 7 years now that actually came true, and I can't believe it did, is an instance where a firm gives a motion for summary judgment to oppose. There's 8 issues and 5,000 pages of discovery. This is probably what? Maybe a 80 to 100 hour project. The firm says, I want you to do this in 15 hours. No matter what, in that situation, everybody's going to lose. And here's why. Even if you somehow manage to stop time and get the project done in 30 minutes, the firm is still going to be mad at you because you spent double the amount of time they wanted you to spend. So that means you're either writing off 15 hours of your time, and then the firm's never going to hire you again, even if you've done a great job, or it means you are going to decline the project at the beginning. And in my life, I would rather decline the project at the beginning than spend my time doing something if I'm not going to get paid. So that's just something to be aware of. You definitely want to be on the same page with the firm. And that motion for summary judgment thing, that exact thing happened to one of the attorneys in my group. And even though I've been warning people for years, like, it happens to the best of us. And a lot of the time, it's because you just get used to the law firm scenario where you just say yes to everything and somehow think that, you should do some totally unrealistic thing, which, again, it's up to you, but if it were me, I would say no to that. The last thing is to be really honest and communicate frequently with the firm about your time, your progress. If an unexpected issue comes up, make sure you communicate that to the firm, so that way they can tell you yes or no. Like, oh, I did this research project that you asked, and I have come across these 3 other issues that are ancillary to the original question. Do you want me to go and hunt this down or not? That's something that is going to be the firm's decision. And if they say no, then you just move on. The other one is being honest about your time and when you can turn things around. If a firm comes to you and says, I need this by Tuesday at 10, then if you can't do it by Tuesday at 10, you really need to say that. I can't get it to you by Tuesday at 10, but I can get it to you by 11, by Wednesday at 4. And so that way they know that they can manage their expectations and their client on their end, or they can, find someone else to do it. The worst thing you can do in this situation is to say, oh, sure, I'll get it to you by Tuesday at 10. And then Wednesday rolls around and they don't have it yet. They're going to be really upset. So it's just important to be honest. If something comes up and for some reason you can't meet a deadline, tell them right away. Don't just, don't continue to hope that you're going to be able to get it done. Okay. I'm getting a couple questions here, so let me just see if I can answer this. If you're a recent graduate from law school, would you advise to start working as a freelance lawyer right from the beginning, or would you advise to work in a law firm for a few years and then get started on this path? I always advise to start with a law firm for a few years if you can, and then you can get started as a freelance attorney. That's the best case scenario if it's possible for you. Freelancing before you really have experience is very difficult, as I mentioned at the beginning of the presentation, because law firms, if they're bringing someone in on a project basis, they just don't have time to train you. Okay. So those are some best practices, and I'm going to talk about some pitfalls. I mentioned some of these in the previous slide, but take all the time you need is usually false. Turning in your timesheets late, that's another thing. You always need to be recording your time. You need to record your time with detailed time entries. The more detailed you are, the better off you will be. I also recommend that if you are writing off time, then make a note of that in your timesheets, so that way you're letting the firm know that you've spent more time on this than you're actually charging them. Sometimes they want to see that. Sometimes they want to come back to you and say, no, I think we should charge the client for this. And they'll ask you to actually charge. That way, again, everyone's on the same page and we're just being very open and direct with the communication. You need to turn your timesheets in as early as you can. If the project is over for the month, give your timesheet to the firm, or however they want to receive your time. And the reason for that is because that way they're able to bill their clients for your time. If you give them your time late, then number one, it's going to take you longer to get paid. And number two, it's much more difficult for them to bill their client. So again, the more you can help the firm get their timesheets out timely, then the better off you will be. If you take a long time to respond to emails, then a firm might get nervous. Failing to set your rates or time estimates in advance, that that can be really awkward. Well, because how do you know what you're getting paid, or if the firm has some other idea in their mind about how long something's going to take, and you spent 50% more or 100% more time than the firm wanted, then it's going to be much more difficult at the end to get payment. And then again, over-promising and under-delivering. That can be a tricky situation if you say that you're going to give them something on a certain day, you're going to give them some project, and you don't. The more on point you can be with, if you can, if you say you're going to get it to them by Tuesday afternoon and you get it to them by Monday night, the firm is only going to be happy with you, as opposed to pushing to the deadline. Same thing with time estimates. If you want to give yourself a little cushion in there when you're giving an estimate, that way the firm is only going to be happier. So for example, if the firm says, I don't want you to spend any more than 15 hours on this, if you can get it done in 10 or 11 or 12 or 13, great, the firm is going to be really happy with you. You obviously make sure you're doing the same quality of work that you intended to do. If you do it in 16, then they might not be too thrilled unless you've gotten clearance before you do that. So again, it's just all being open, honest, transparent with the firm. That's just the best way to go. That's the best way to be in general. So hopefully that's helpful. Okay, so it looks like I've got some questions. One is, can a firm require a freelancer to have separate malpractice insurance? Well, I mean, a firm, I guess, can require anything they want, and then it's up to you. Again, as I mentioned before, when I discussed the malpractice insurance, it's a really gray area that a contract attorney's malpractice insurance policy would even apply, but that's up to you to discuss with the firm. Should the firm's existence of malpractice insurance or lack of be disclosed in the written agreement? I do recommend discussing the insurance situation in the agreement. That way, the firm has to sign that they actually carry coverage. That's something that can only protect you as the contract attorney. And then what are your suggestions for time tracking methods of projects? Well, to me, the best practice is to give it in a copy and pastable format, because then that way the firm can turn around and load it into their own system fairly easily. If you're going to create an invoice in some other format, you can do that. It's just that now the firm has to turn around and somehow double up work and put it into their own time system. But each firm is different. Each firm may have a different request. So I would just discuss it with the firms. Let's see, another question. Do you find any ethical implications of advertising your services in states where you're not licensed or admitted to practice? I don't actually know the answer to that question. Probably not, but again, because if you're not practicing law, but it might be kind of tricky because, if you're advertising in a state where you're not admitted, a lot of firms, not all, but a lot, tend to be fairly particular and they want someone licensed in their own jurisdiction. But I don't know the answer to that. I haven't actually researched that question. So most of the questions I'm getting here are about recent grads and how to get work as a recent grad. And I think I addressed this earlier in the presentation. The best thing you can do is just to meet as many people as possible, either online or in person. explain what you're looking to do, and ideally find 1 or 2 firms that are willing to train you. That's the best thing you can do. If you are really looking to, if you want to do freelance work as a career, and you don't have a secondary source of income, I can tell you that most of the time it takes a pretty long time to build up your firms, to build up the amount of hours that you would need for full-time. It's not an easy thing to do. There are just so many factors involved, a lot of which are totally outside of your control, including luck. So it can be really tricky to do as a brand new grad. This type of work is the best for someone who has been practicing for quite some time. I hope that helps. It's not impossible, but again, the best thing is to find a firm that's willing to work with you. How many big law firms currently use freelance? I don't know the answer to that question. There's really, as far as I know, I'm not aware of a lot of data on this. I think that most big firms tend to, they'll work with doc review type companies, but as far as substantive work is concerned, it's a little bit more difficult for big firms to use contract attorneys. And the reason is because they have salaried associates that need to be fully occupied before it makes sense to bring in an outside person. So, see, here we go. If you do not have the opportunity to work at a firm prior to freelancing, what other work experience could be helpful? This is really tricky to say. If you have some type of specialized expertise, it might be useful for that type of firm. So for example, if you have engineering experience, you might be more attractive and useful to a firm that is working in product liability, for example. Same thing, if you have a science background but are not admitted with the USPTO, you still might be useful to an intellectual property firm, for example. But this is going to vary quite a bit. Okay, next question. If, as a freelancer, I have direct contact with the client, is it prudent to be included in the services agreement with the client to have malpractice coverage? Possibly. I haven't actually heard of firms that do this, but it might be worth checking with the firm. A lot of the time, the firm doesn't need to do it with their client, but just needs to do it with their carrier. So they might need to notify their carrier that they're working with a contractor and ask if there's anything that they need to do. And I do advise them to do that. What are some professional ways to be paid? Whatever works for you and the firm. I would err towards whatever works for the firm, because if it works for the firm, then the easier it is for them, then the quicker you'll get paid. What do you suggest to the new lawyer trying to build his own practice instead of working freelance for a law firm? Oh goodness, well, this is an entirely separate topic that that could take another hour for me to go through, but again, it's going to be a lot of networking, a lot of learning, a lot of CLE. I have to believe that the ABA has some presentations that have already been discussed about this. You could probably search through their archives and see if you can find some tips on building a new practice. But I do think that that's something to consider, because rates as a solo practitioner are typically going to be higher than if you're working for a direct client than they would be for a freelance attorney, unless you are very specialized. Okay, what areas are most in demand? This varies by day. I get calls every day, and sometimes we have a very heavy real estate day. Sometimes we have a really heavy employment day, or litigation, or, whenever I talk to people, I tell them the same thing, that I have absolutely no idea what someone's going to ask me today or tomorrow or next month. It's just impossible to know. History is no guide. All right, and probably the last question I'm going to be able to take here is it advised to have multiple state bar admissions for freelance work as an attorney with 3 to 5 years experience? It doesn't hurt, but I don't think it's necessary if you don't want to do that. I know for me, if someone told me that I needed to go take another bar exam if I wanted to get more freelance work, I would probably do a hard pass on that because it seems like a lot of effort to go through that's really not necessary. If you already have those bar admissions, then sure, they're helpful. Or if you have a genuine reason to be admitted in multiple states, so for example, you've moved to a new state and you feel like being admitted in the new state, then it might be helpful just from a networking standpoint because now all of your professional connections are going to be in a new location. So it might be helpful to be admitted in that place, but I don't think it's necessary. Thank you so much, everyone, for being here today with me. I'm going to turn it over to Emily, and I really appreciate you all taking the time to listen, and I hope this was helpful.
Thank you so much, Erin, for all your practical and helpful insight on how to create a flexible practice becoming a freelance lawyer. And thank you all for attending today's webinar. Please be sure to check out our website at ambar.org/careers for upcoming free career-related articles and webinars. Recordings are on our website now. And on your screen are some of our upcoming programs. We have Choosing a Destination, Proactively Managing Your Career as a Mid-Level Associate coming up on September 8th in the Career Advice Series. And in the Career Choice Series, we have one coming up on Lawyer Professional Responsibility and Loss Prevention on August 25th. You can also be sure to connect with us on social media, and you can check out our About page to get to know our board. Thank you again for joining us. Please fill out the survey before you go, and have a great day.